Hello, it's Caitlin Jenkins, the family law vlogger here. This is the latest in the Stages of Divorce series, and today I'm going to be looking at questionnaires and how they're used in financial remedy proceedings. So what is a questionnaire? Well, its formal name is a questionnaire and request for documents, and it's usually used after people have exchanged their Forms E, which are the financial disclosure documents that I've covered in other vlogs. So once they've exchanged Forms E, each person has the up-to-date information plus supporting documents, which are supposedly putting the case of that person as to what their assets are. So what house they've got, interest in property, what other investments they've got, savings, investments, bank accounts, what business interests they have, or for example, interest in any trusts, and what their income is, plus supporting documentation. So that's what's in Form E. So the request for documents questionnaire document is the next document that you're allowed to file in the court process to raise questions. The clue is in the name. To raise any questions that you have about the other person's Form E that they filled in. Now, what I tend to say to clients when we're looking at whether to do a questionnaire is for them to have a look at the Form E and to write a list of questions about every question that they have arising out of the Form E and all the supporting documents of their spouse's Form E. And then we'll sit down and look at it together, because not every question that you might have about your spouse's Form E and the documents that support it are appropriate ones to raise in a questionnaire. Ones that would be appropriate would be things like, for example, you haven't disclosed a bank account that I know you've got with Santander, you've disclosed all the other bank accounts, but you haven't disclosed this one, please provide details. Or I think you've got an interest in your grandmother's property in another part of the country and you haven't put that in your Form E, please explain and provide any documents. Or sometimes you want more complete documents. For example, you may have copies of a tax return for a particular period of time, and it might be relevant and appropriate to be asking for a tax return for a longer period of time. So those sorts of questions are appropriate for a questionnaire. What isn't appropriate is something that really should be dealt with by an independent expert. For example, any valuation issues. So if you've got a dispute arising out of the Form Z where one person's valuing a house at one value and another person's valuing a house at another value, it might be that can be solved by getting some estate agents round to give their view on a marketing appraisal, or it might be that a third party needs to look at it. So you need some sort of independent third party, jointly instructed, a chartered surveyor, to give an independent view of the value of the property. Same point applies with values of a business interest. The Form E might say that a person has an interest in a family business and they put a value on it of X. And you may think, well, the value of that is a lot more or a lot less than that, depending on the circumstances. It might be appropriate to ask in the questionnaire how they've arrived at the figure on their Form E, but it's more likely to be appropriate in those circumstances to be considering getting an independent single joint expert to value their interest or your interest in the business. So those sorts of things probably wouldn't form part of a questionnaire. The other thing that doesn't tend to form part of a questionnaire is detailed questions that your solicitor would be more likely to say to you will probably form part of either conversations in negotiation or part of the cross-examination if you ended up in a final court hearing. And those are things like questions about, for example, the schedule of outgoings or the budget that your partner may have attached to their Form E. So the schedule of outgoings will be a detailed list of expenditure that your partner expects that they will incur for living in either the family home going forward or in a future home as part of mounting their case about what they need for their future life. And so what you don't tend to find courts find helpful is if in the questionnaire says, well, why do you think that you will need to spend X on holidays? Or why do you think that you would need to spend Y on travel or travel insurance or on the children's costs at a school? Because those are more questions that should be asked in oral evidence rather than in the questionnaire request for documents. When is a questionnaire done? Well, it's usually done after the Form E has been done, before the first court appointment. And if there's a dispute about how relevant the questions are, then the judge at the first court appointment can decide which of those questions should be asked. And as a rule of thumb, judges don't like fishing exercises. So what they don't like is somebody trying to use the questionnaire as a way of going back through, say, 3, 4, 5 years worth of expenditure during the last few years of the marriage, or having a good old fish around to find out what somebody's been spending since the separation, unless it's relevant to the division of the finances on the divorce. So A questionnaire is a very helpful tool to complete the picture to enable you to then start negotiating. What it isn't is carte blanche to ask all sorts of questions which a court or your solicitor will advise you are irrelevant or should be dealt with in a different way. As always with the Family Law Vlog, I can only give you some general information. If you need advice about your specific circumstances, then please do contact me or one of my expert colleagues in the Mills Reeve Children and Family team, and they'll be able to help you. Thank you.